Good evening, everyone. Welcome to the City of Annapolis Board of Appeals regular meeting for July 2nd, 2024. The meeting is being broadcast on the City of Annapolis YouTube channel, so look your best. The agenda for tonight's meeting you can find on the City of Annapolis website. On the agenda, you'll find links to the YouTube channel. You'll also find a link to a form that you need to submit if you need to testify or submit written comments before the board. And you'll also find links to the city's website where you can find information about the cases that we'll hear tonight. So any written comments we've received by noon today and cases that are coming up tonight will be have been provided to the board and the parties and will become part of the record. Let me remind everyone that communications with the board, with any member of the board about any case by anyone other than a party to the case, must go through the comment form. You can't just call a member of the board and talk to them about one of our cases. All communications by parties with the board should go through Kim Consoli, our liaison in the Planning and Zoning Department. No one should contact any member of the board directly about a case under any circumstances. So we'll begin the meeting asking Kim to take a roll call.
Mr. Gallagher?
Yes.
Mr. Zazali?
Yes.
Mr. Walsh?
Yes.
Dr. Chen?
Present.
Mr. Hector?
Present.
Mr. Chairman, we have all five.
Great, thank you. So we have a quorum. Have the members of the board had a chance to review the agenda?
Yes.
Are there any corrections or additions? Sir?
To proceed with the agenda.
Is there a second?
Second.
All in favor?
Aye.
Thank you. That takes care of that one. We have now minutes, draft minutes for the meeting on June 2nd, 2023. Any corrections or additions to the draft minutes? Is there a motion?
So moved.
Second?
Second.
All in favor?
Aye.
Aye. Thank you. Finally, we have, I think we circulated a draft of our decision in the 11 Gilmer Street variance case. Has everyone had a chance to glance at that?
Yes.
Are we all on board with signing off on it?
Yes.
Yes.
Great. All right, thanks. So our first case tonight is application for a special exception 2024-006, application by Terrence and Gina Fitzsimmons, owners, and Chang and CH Investment LLC, applicants to establish a restaurant with more than 50 seats in the existing building located at 938 Bay Ridge Road. Kim, would you like to introduce the case for the city?
Yes.
Can you speak up, please? We can't hear everything.
Chair's moving and you're talking.
Thank you.
Go ahead, Kim.
Okay, well, in case you didn't hear, this is a special exception for 938 Bay Ridge Road, which is also known as 918 Bay Ridge Road, which is kind of confusing, to allow a restaurant with more than 90 seats in the B2 district. For an application like this is a pretty straightforward special exception. The previous retail use of this, it's an existing building with existing parking. The previous use has the same amount of parking spaces as the proposed use. So there's really no site improvements. This is more of an interior reworking than anything on the exterior. I think the only thing exterior they're doing is providing a handicap ramp for the restaurant. We've received no public comments for this at all. It's in compliance with our comprehensive plan, as I've noted in my staff report, and the city supports this.
And are you satisfied that the notice and posting requirements have been met?
Yes.
All right. I noticed that there's been an appearance of counsel. Would you like to identify yourself?
Yes, Kira Wheatley, compliant and Weber, on behalf of the applicant, 200 Westgate Circle, Suite 500, Atlas.
On behalf of the applicant and the owner, or just?
Just the applicant,
Just the
Chang and CH Investment. The owners aren't here tonight. They provided an owner authorization.
I'm sorry, your microphone. the green light on?
Yes,
Can you just lean in
yes.
a little bit closer? Thank you.
We submitted an affidavit from the owner, authorizing the applicant to seek the special exception use, but they're not here tonight.
Yeah.
Our understanding they're in favor of the
Fine.
application.
I notice you've presented us with a very smartly packaged set of exhibits. Is there anything in here that wasn't part of your application process?
Yes, so the affidavits for posting, I believe there's an SDAT, 2 SDAT sheets in there.
What are the SDAT sheets about?
So there, the property is listed on SDAT, or was listed as 938, it's commonly known as 918 Bay Ridge Avenue. I think it was recently corrected, so we have for you the original SDAT sheet with the 938 address and the new SDAT sheet for the 918 address.
Okay.
There's also the resumes for the expert witnesses.
I don't know that any of us noticed any oversight in the mistakes, so thanks for correcting them. Let me say before you start that we have read the application with all of its exhibits. We've read the staff report and recommendation with all of its exhibits. I think in substance, that's pretty much what's in your package here. So we're very familiar with that. I'm not sure what expert testimony we need, and we generally don't qualify experts. But if there's something you need that you think isn't adequately covered in your materials, this is your opportunity to tell us about it. So the floor is yours.
Well, just as a general opening, I have here tonight Kevin Wang, who represents the applicant. I will proffer that most of his testimony would be what's included in the statement that you guys have read and accepted as part of the record. You know, that the hours of operation for the restaurant, that there's no outdoor seating or service, that there's no change impact on neighborhood, that the use is 490 seats. So in an effort to be as expeditious as possible, I'll let you all have any, or ask any questions if you need to, and just move to our other that's okay. Oh, I think it's working now. Oh, there we go. That might have been my fault. Okay. We have with us Peter Miles from the drawing board, who's the architect who created the floor plans for the restaurant. John Arison, who's here to testify about the community need for the proposed use, and Mark Evans from Drum Loika, who created the site plan for the property. So I'll go ahead and start by calling Peter Miles.
Hello.
Keep in mind, we've seen the plans, we've reviewed them, so.
Great, so I'll keep it short then.
Peter, can you just state your name and address for the
Yes,
record?
personal address or business?
Business is fine.
Business. Peter Miles from the Drawing Board Inc., and our address is 1500 K Street Northwest, Suite 273, Washington, D.C.
Peter, can you just give the board a general overview of the floor plan, maybe specifically point out the ingress and egress points of the, from the parking lot into the restaurant, and the general layout of the, where the seating would be?
Yes. So the building footprint remains the same, and this is largely an interior renovation. We are restriping the parking lot to add necessary ADA parking and van spaces at the front. So the main entrance is the front of the building, which will contain most of the seating and restrooms. Then the building is kind of split in two, and there's a rear area. So there's a dining portion in part of that rear building, which has a small connector. Then the kitchen is on the upper level and part of the lower level, the partial lower level at the back. So service in will be through the back as far as deliveries and trash, and then patrons will enter either from the front door or the rear door for rear dining, where we are adding an accessible ramp, which is just a low concrete ramp, but right now the door has a couple steps down. So we're updating that to make the building accessible.
Right.
And Peter, just to note, on the floor plan, on the first page of the floor plan, there's a noted service bar in the middle of the front part of the restaurant where the majority of seating is. Can you explain what that service bar is going to be used for?
Yes, that is for staff to prepare drinks for wait staff to then take the tables. It is not a bar for patrons to order from or sit at.
Okay. And to your knowledge, are there any additional adequate utilities that need to be added to the restaurant in order for it to function? Adequate
No.
facilities? No? Okay. Are you familiar with the code requirements for parking in
Yes.
relation to the amount of seating that is proposed for this restaurant?
Yes, we need 30% of the seats as required parking spaces.
And as Ms. Burke had noted, the staff report mentions that there's no additional parking proposed. Is that accurate from your understanding?
There are 2 spaces in the rear that appeared to have been unstriped at some point, so we're restriping those spaces to have 27 total spaces on site.
Okay. And can you briefly explain, I know you mentioned offloading and loading. Do you know where the offloading and loading for service vehicles would be, where it would come from in
Yes.
relation to the building?
So there is, at the rear of the building on the lower level, there's the main kitchen. There are entry doors at that level. So the trucks would come through the side road, drop off deliveries, pick up whatever needs to be done at the rear of the building, and then continue out through the site.
Mr. Miles, have you had an opportunity to review the criteria for the special exceptions in restaurants within this zoning district in this city?
Yes.
Okay. And do you have experience in the past with obtaining special exceptions for restaurants or other uses within the city?
Yes, we have done multiple restaurants in the city of Annapolis.
Is there anything in the special exception application that would cause you concern about meeting the necessary requirements?
No.
Okay. And in your opinion, does the special exception meet all the necessary requirements to obtain approval?
Yes.
Okay. I think that's all I have for Mr. Miles. I'll go to Mr. Mark Evans, unless there's questions. Mr. Evans, can you state your name and address for the record?
Mark Evans, Drumlick and Associates, 1410 Forest Drive, Suite 35, Annapolis, Maryland.
And can you give the board a very brief description of your role with this project?
I'm principal at Drumlick and Associates, and I am the senior project manager for the project.
Okay. And you created the site plan for this restaurant that's proposed at 918 Bay Ridge, is that correct?
Correct.
Okay. Can you explain to the board just some general key features of the site plan that address certain applicable special exception criteria?
So the main requirements and the changes in this site were extending there were 2 existing ADA parking spaces at the front of the site now that were short of the required 18 feet of depth. We expanded those 2 parking spaces in the front, and we added an ADA ramp for the secondary entrance in the back and a dumpster pad in the far back northeast corner of the site because the existing dumpster that's on a roller in the back was currently in one of those parking spaces that we are now using as parking.
Okay. All right. And the extent of the renovations or changes to the lot, would you consider those minor alterations to the?
Yes, I mean, it's a
Existing
minor
building.
adjustment. There were 2 ADA spaces that just were short, and then the ADA parking ramp by the rear, second entrance, the minor entrance.
And do you have any concern that these renovations would have any impact or disruption on traffic in the neighborhood?
No, I did not.
Do you have any concerns that this use would require additional adequate facilities or cause constraint on the existing adequate facilities?
No, I do not.
And do you have any experience with obtaining special exceptions in the past in the city of Annapolis?
I've worked in the city of Annapolis on several special exceptions over the last 30 years.
Okay. Is there anything in the special exception application that would cause you concern about meeting the necessary requirements?
No.
And in your opinion, does the special exception application meet all the necessary requirements to obtain approval?
Yes, it does.
And I'll move to Mr. John Harrison.
Thank you.
Mr. Harrison's going to tell us that they're not wasting their money when they invest in this place.
Of course not. I'm heavily invested in this city.
John, can you just state your name and address
Yeah.
for the record, please?
John Harrison, 707 Glendon Avenue, 21403.
And I know the board is very familiar with you, but for the record, can you just provide a brief description of your background in city planning?
I think we have it in here.
Okay, all right, great. Mr. Harrison, have you reviewed the application materials submitted for this special exception request?
Yes, I have.
Okay. Are you familiar with the current use of the property?
Yeah, I am.
Is this, is the proposed change in use significant enough to believe that there'd be any negative impact on the public health or general welfare?
No, and in the interest, I guess, of redundancy avoidance, I have read the statement in support of the special exception that was submitted by Hyatt and Weber. I have read the staff report. I visited the site. And in terms of all the findings that need to be made, the findings for special exceptions, the specific findings for restaurants in the B2, the general findings for restaurants citywide, and I agree with the discussions that were put forward both in the statement of support and in the staff report. And that testimony could easily be my testimony, and I could add a few things here and there, but it wouldn't be enough to sway the board one way or the other.
All right. That answers all my questions then. I'll leave it to the board if they have
Great.
any further questions.
Thank you. Questions from other board members? Michael?
Thank you, Mr. Chairman. Kim, just a few, just to clarify for me, so this is the building that the previous use was for decor design?
Yeah, yes.
Okay, and there are currently 7 spaces in front on that, parking spaces in front for that use?
I'd have to look. It's on the site plan.
I have it here, so
Okay.
and that's the question I have, and it may be more for one of our witnesses here.
There were 7 spaces
There are
in
7,
front of the parking
to
lot. and
expand to
we've-
8?
We've aligned that striping for 8 spaces now along
Okay.
that.
And how many seats in the restaurant
90.
proposed?
90.
90 seats. And what's the restaurant ratio of parking spaces for restaurant usage?
30%.
30%.
27 spaces.
So where are the additional spaces? I listened to the testimony, and I'm looking on the drawing here, but I'm not finding additional spaces to
So
satisfy the
there's
30%.
26 spaces on the site in the existing condition, and that adjustment from 7 to 8 in the front gives us that 27 space.
Where are the 26?
If I don't mind interrupting, I think, because I had this when I was looking at the site plan too, it is kind of hard to count, but if you look at the spaces abutting Bay Ridge, there's proposed 8 spaces, that's where the restriping will occur. And then on the side, there's 11 spaces there. And then there's the 6 spaces that front the building, and then there's 2 additional spaces in the rear of the lot. So if you look at the top left corner, it's a little hard to see, but it says EX 2 spaces, and that's where the additional,
I heard
yeah.
a gentleman talk that there were 2 spaces that were not striped.
Yes, so
the
those will
ones
be
you're referring
restriped
to.
as 2 spaces.
And the 11 are along the side of the building, between the adjoining building that has the flower shop and the barber shop right there, there's 11 spaces there?
Yes. Mark is better to answer that, but.
It's actually, they're adjacent to the Chase Bank
At
site.
the Chase Bank, okay. Now, just last question I have, is this building a part of the rest of that commercial area there? No, that's a separate entity,
Yes.
okay. The reason I asked, we had a parking issue on a previous matter that we had here related to that part of the
Right.
commercial space. Great, thank you.
Christian? You good? Mr. Heckler?
Thank you, Mr. Gallagher. In addition to Mr. Walsh's question, how many spaces are being allocated handicap?
2.
Thank you.
Does the applicant operate any other businesses in Annapolis under a special exception?
No.
No? Okay, thanks. I don't have any other questions. If we're done, we'll close the record. The exhibits, the new exhibits, if any that you gave us tonight, will be marked and made part of the record.
There's no special staff recommendations, like the standard stuff.
Yes, that's right. Typically, we delay our deliberations until the last item on the agenda, but since I think the case that follows you might take a little while, if it's all right with my colleagues, I suggest we deliberate this one now.
Yes.
Does that make sense? Okay. Who would like to start? Michael, you had the questions, so you can start.
Yeah, Mr. Chairman, I'd have to agree with what the staff has proposed and in relation to this project in terms of an infill project that's already being utilized in that area. I don't think traffic is be an issue. My only concern was parking, which you satisfactorily answered. I'm a little, that road, the access road that comes in from behind the bank into that building there is a little fluky, so I'm hoping that you'll improve not only the surface, but the access to it and how best to have that traffic move in one direction there. But I see no reason, I do believe that the proposal does meet the criteria, and I'd be in favor of supporting the variance.
Any other discussion?
This is, no? Good.
You're good? Is there a motion?
Mr. Chairman, I move that variance 2024-00007 be approved, and included in my approval would be the recommendations in the staff report be required as a part of the approval.
Second.
All in favor?
Aye.
Aye. All right, congratulations. Sorry.
Thank you.
Did you enter this, Mike?
Oh,
Special exception. Did you, yeah. Did you enter this?
I apologize.
yes,
I was looking at the other one.
but you've got the right person. All right, we'll fix it.
Six.
I was looking at the file for the next one.
Yeah, you're jumping
I
ahead.
was jumping ahead.
All right, we'll fix that. All right, next we will take up variance application 2024-007, the one that Mr. Walsh was so anxious to get to. It's an application by Mona Design Build, Inc., owner to remove 12.25% more woodland than the 30% allowed for the construction of a new single-family dwelling on a vacant lot located at 109A Moss Haven Court. And we have some appearances. We have someone for the applicant, is Mr. Scruggs?
Yes, Chairman Gallagher. My name is Jonathan Scruggs. That is S-C-R-U-G-G-S for the purposes of the record of the Law Office of Matthew S. Evans III, representing the applicant in this matter.
All right, and we have an appearance for an objector.
Good evening, Mr. Chairman. Trip Fulton on behalf of Allison Webster Giddings. My client owns property adjacent to the property subject of this evening's variance application.
I saw your appearance and will welcome you as a party, you and your client. If you'd like to take that table, you'd be welcome to.
I was going to ask exactly that. Thank you.
Can you take that microphone with you?
Yep.
Good. We do have public comments in this case. We've got several people signed up to give oral comments. And before we actually launch into the case, we have a couple disclosures to deal with. Two of the folks signed up for comments are Terrence and Suzanne Smith. They're friends of my wife and I for many years. They live at one end of Moss Haven Court. Last week, I think it was, in a phone call with Mr. Smith, he mentioned that he got a notice in the mail of this hearing. And I confirmed that we do have a matter on our agenda for Moss Haven Court, but that I was unable to discuss it with him. Beyond that, in social events arranged by the Smiths over the last few years, I know I've met a number of other neighbors from that street, including the objector, Ms. Giddings. But in my view, I don't think any of those connections cause me any difficulty in participating in this case on an impartial basis. And I propose to continue. And did you have a disclosure you wanted to make, Mr. Walsh?
I do, Mr. Chairman, thank you. I reside in the neighborhood that is adjacent to Moss Haven Court. I know the protestant to the case just from being in the neighborhood, so I wanted to give that disclosure as well.
Okay. Does anyone have any problems?
Chairman Gallagher, I trust that you will be fair and impartial, and Mr. Walsh, I appreciate the same, and I have no objection.
Thank you.
Thank you.
Okay, so as we did in the last hearing, which I think you observed, we usually save the board questions to the end. That doesn't mean any of you shouldn't interrupt if you feel like there's something that you need an answer to. But I thought before we started, there are a couple of questions I'd like to ask to make sure we're all on the same page, what the issues are we're dealing with tonight. So, Kim, I take it that we don't need a variance, the applicant doesn't need a variance for setbacks, for height, for lot size or coverage. Is that right?
No, he does not.
Okay. So what we're talking about is the variance from 30% to 42%.
Correct.
And from looking at the filings, that the application that was filed, and from the statement in opposition, it looks like there's agreement, at least among counsel there, that the issues we're dealing with are, have the requirements been met generally for a variance under 212840, and have the special requirements been met for a critical area variance under 2154-160. Is that everyone on board with that?
That is my understanding, Mr. Chairman.
Mr. Fulton?
Yeah, correct.
Yes.
Kim? Okay, good. All right. So let me remind all the parties and anyone who would like to give comments later that this board is concerned only with those requirements in those two sections of the Annapolis City Code. There's 7 requirements under the first section I mentioned for generally for variances, and there's 7 more overlapping requirements for variances under the critical area rules. Those are the only thing, those factors are the only things that this board can take into account in deciding whether or not to approve the application for variance. So I'd urge everyone to focus their attention on those requirements. And I think that'll make the hearing go a little more quickly. Okay, so Kim, would you like to start for the city?
Sure. This is a variance to clear an additional 12.25% of the developed woodlands. This lot was considered developed woodlands by our city arborist. He did submit a memo to the board defining what that is, and he also did state in that this lot could not be developed without the removal of this one tree, which is mainly what makes this lot the developed woodlands. There's one, I think it's 49.5-inch tree that is in the front of this property. There's really no way to develop this lot without the removal of that tree. we've looked at this, city staff has looked at this, relocating it, shrinking it, moving it back. There's really no way to avoid disturbing that tree, no matter who would come in to build on this lot. Anybody that comes in and wants to build a house on this lot, which is a legal existing lot. It was existing before the critical area laws came into effect. It's part of the Moss Haven subdivision. It is about the same size as the other properties on the street. This one just has never been developed. So the city supports this variance based on that the arborist stated that this project could not be developed without the removal of the tree. One of the public comments that we received was from, I guess, the previous owner of this lot, and she did state that that she's been trying to keep the tree healthy, that the tree is near the end of its lifespan. I know the applicant will, they had an arborist look at this tree. They will give testimony on that. When we look at cases like this, we look at, from the available records that we have in the file, because this is such an old subdivision, we don't have a lot of records on the existing development around it, but what we do have in the file that I could find, several of the lots adjacent and around this are about at the same percentage of lot coverage as this is proposed. And there are grading permits that we have. In particular, the house across the street, they also had to remove trees as part of their development. Their house is significantly larger than this one. This house isn't the smallest house proposed on the street, but it's also not the largest house on the street. So we feel it's very in keeping with the neighborhood. I know there have been comments on moving the house back further to the rear of the property. That would really go further into the critical root zones of the trees on the neighboring properties. So keeping it forward is what is, as this plan shows, is what the city is supporting. I know the arborist will, when it comes in for a permit, will look at neighboring properties and the critical root zones of that and take the steps necessary that he would think would be necessary to help save those trees on the adjacent properties. And I know that the applicant is going to testify to other things as well.
Are you satisfied that notice and posting have been met?
Yes.
Okay. The counsel for either the applicant or the objector have any questions for Ms. Burke?
No, Mr. Chairman, I do not on behalf of the applicant.
Mr. Fulton?
None for the city.
Okay. All right, for the applicant.
Mr. Chairman, actually, can I clarify one thing?
Yeah, sure.
Ms. Burke, can you expound a little more on your statement that this lot is the same size as all the other lots?
I said it's about the same size.
On both sides of the street?
Well, the next door lot looks to, and the lots on either side of this look to be about the same.
6,500 square feet.
I'm just going by what the plan that's submitted is.
Thank you.
Mr. Chairman, may I ask for a clarifying direction to the audience to reserve comment for preservation of the record to time for when the audience is permitted to give testimony?
That's fair enough. Please, if you're here to observe things tonight or even to testify later, save your testimony until it's your turn.
Thank you, Mr. Chairman.
All right, Mr. Scruggs, you have witnesses that you'd like to?
I do, Mr. Chairman. Principally, I would like to call a representative of MAF and Associates, Mr. Matthew Forgan, who is the engineer who's developed the designs here. I'd like to call him first.
And what's his name?
You can spell first and last name. Please spell your first and last name.
My name is Matthew Forgan. My company is MAF and Associates. I am not a licensed engineer. My company does engineering both in the city.
Before you start, we need to ask you to affirm that subject to the rules for perjury, that the testimony you give tonight will be true to the best of your knowledge? Can you do that?
I do.
All right, go ahead.
Again, my name is Matthew Forge, and my company is MAF and Associates. The address is 55 Jones Station Road West in Severna Park, Maryland, 21146. As I stated just briefly, I am not a licensed engineer. My company does engineering in both the city as well as the county. We have a licensed engineer on staff.
May I proceed with questions, Mr. Chairman?
Please.
Mr. Forgan, can you please identify your role with MAF and Associates LLC?
Oh, I own MAF and Associates
And how long have you owned MAF and Associates LLC?
since 2003.
And prior to 2003, where were you employed?
Anarix Incorporated in Millersville,
And how long
engineering
were you employed-
firm,
How long were you employed there?
91 to 2003.
Can you give the board some identification as your background into site development?
So, as I said, in 91, I started doing drafting work for an engineering firm. Quickly became project manager at that company. Stayed with that company doing site development, grading and sediment control, working under the principal engineer. That engineer is also the engineer I work with currently since 91.
And what is your engineer's name?
Michael Warner.
Mr. Warner has certifications, licensures as an engineer?
Yes, he does.
And he operates under your direction as ownership operator of MAF and Associates LLC?
Correct.
All right. Can you tell me how you are familiar with the property that we're here to discuss, which is 1009A Moss Haven Court, Annapolis, Maryland, 21403?
Yes, I was hired by the owner to prepare grading and sediment control plans for this project. And as we were going through that process, we realized that in developing this site, we had to clear over the allowable clearing for this area.
And what, if anything, did that tell you about what you needed to do from that point forward?
Well, we needed to submit a variance application for this.
All right, give me a brief description of the property that would be identified as lot number 6 within this subdivision, correct?
That's correct.
Can you please give me a description of the property as it currently exists?
Sure. It's a relatively small property, 50 by 130, 6,500 square feet. As it was stated earlier by the city, there is a large tree in the middle front of the property. Development of the property for a single-family home, driveway to support 2 off-street parking spaces, and unfortunately, the amount of clearing that's needed gets us into a variance.
Okay, what amount of clearance is needed?
Our proposed clearing for this requires us to clear over the 30%. We are proposing to clear 42% of the site.
And when you're talking about clearing 42% of the site, is there any specific vegetation that you're referring to that's a required clearing?
So when I'm talking about the percentages of the site, I'm referring to canopy cover. We're always required per the city to deal with the canopy cover on the site.
Okay, and when you talk about canopy cover, what are the regulations the city requires? If you know.
I'm sorry, I'm not understanding the question.
So if, in terms of canopy cover, what exactly are you asking for a setback to, or I guess a variance for?
A variance to exceed the 30% clearing.
Sure, and have you referred back to City Code Section 21.28.050 A through G, which talks about your variance request?
Yes, I have. In my variance request, I cover all of the A through G of that section.
Sure. Is that a letter dated May 13th, 2024, which is already a part of the record?
Yes, it is.
And can you give me a brief indication of how this particular variance request meets the requirements of the county code, specifically to the section I referred, 21.28.050 A through G?
Sure. I mean, to make it simple, there's just no way of developing this site without exceeding that 30%. That large tree alone, the requirement of taking that tree down pushes us over that threshold. We looked at this site several times. What's unique about it is relatively small legal lot. with over 90% forested area or developed woodlands on the lot. So in order to develop it with this large tree, there's no way of staying under. In my opinion, that is the unique characteristic of this site. The requirement, the critical area requirement on a lot that was approved or subdivided prior to critical area law, we're being restricted as far as what potential development is because of that. And the inability to save a large tree that is required to come down for development.
Is there any other lawful place upon this property that you feel, in your expert opinion, could be placed, that the house could be placed?
In my opinion, no. We looked at this several different ways. Not only do we have a requirement for meeting setbacks, what our clearing requirements are, we also, through the grading and sediment control review, we're required to address stormwater management. So we're required to do something for management for the proposed house. So as we start to try to shift the house down to the south, the back portion of the lot, it starts to eliminate area that it starts to increase the amount of impervious because we're going to have a longer driveway, and starts to decrease the amount of area that we have for stormwater management. So when we looked at this plan, knowing what our requirements were going to be, trying to keep the house tight to the right-of-way, minimize lot coverage as much as we can, and still be able to provide stormwater management on the site.
Now, when you talk about stormwater management, is there anyone that you kind of consult when you are trying to determine how much stormwater management you will need?
Well, we know what the requirements are from the state and also from the city, so we must calculate our required volume based on the requirements of the city.
Now, in discussing application that's already been filed and it's already been made part of the record, the State of Maryland Critical Area Commission, did they weigh in on your application for variance?
They did.
And what was the recommendation?
I believe it was mitigate, if the variance were to be approved, certain mitigation be addressed.
And is that part of your application?
It is. Well, it's part of our actual grading permit application. Mitigation is being addressed with the grading permit.
So it would be fair to say that you're accepting the recommendations of the State of Maryland Critical Area Commission as to mitigation as required.
I believe what they recommended was mitigation on site, as well as potentially paying a fee in lieu. We're going to be ultimately doing both.
So that is to say that you're accepting their recommendations and working with them to provide adequate stormwater management facilities.
That's correct.
Do you believe that there's any, in your opinion, given your knowledge, training, and experience with MAF Associates, is there any negative impact on the lots surrounding this particular Lot 6?
I don't believe there is.
Why not?
Well, we're meeting our required zoning setbacks. We are meeting our critical area requirements as far as total lot coverage. And we're providing the proper stormwater management for the proposed house.
And in reviewing in reviewing your work and your application, did you review other lots and other construction within the community?
I did review houses within the area as it relates to size and placement.
And how does this project compare to other homes within the community?
In my opinion, it's similar in size.
How so?
In that the proposed footprint, when I looked at other homes in the area, footprint square footages were very similar, if not larger, than the house that's being proposed for this lot. Placement, just along the street, placement is very similar as far as the setback from the right-of-way.
And do you believe this application should be approved as principally filed?
I do. I believe we meet the requirements of the city code.
And that would be requirements A, B, C, D, E, F, and G?
That's correct.
And that's reflected as pursuant to your letter that was submitted as part of this application?
Correct. And we also have 21.54.160 C1 through 7 that I feel we meet as well.
All right. And this is a residential property, correct?
Yes, it is.
And it's in a residential neighborhood?
Yes, it is.
And this is a buildable lot?
It is a buildable lot.
And how long has that lot been buildable?
I believe it was developed in 1938.
All right. And has this lot been increased, expanded, or otherwise altered from when it was originally platted to the best of your knowledge?
Same configuration.
All right. And that would be consistent with lots, I believe, let's call it, if I believe that's lots next door, that would be 11, 10, 9, 8, 7, 6, and 5 in that particular community?
That's correct.
And all of those lots are roughly the same size?
Correct.
And they all contain single-family homes?
They do.
And they all abut up to the Spa Creek as this particular property does?
Correct.
All right, I have nothing further, but this particular witness, Mr. Chairman, if you have anything further.
Cross-examination, Mr. Fulton?
Yes, Mr. Chairman. Mr. Forgan, quickly, can you tell me how many trees are currently proposed for removal?
Seven trees.
And are these 7 individual trees specifically designated or identified anywhere in your site plan or application materials?
They are.
Can you show me where?
So if you're looking at the existing conditions sheet, they're light gray, and they have like a scalloped line type. And within the center of that, there's a smaller circle that's representing the tree trunk, and then just to the above that, it calls out what tree size it is.
So for my clarification, are there trees on these plans that are not going to be removed but are still identified nonetheless?
So they're identified, yes, they're identified on the existing plan. Gets a little bit crowded on the proposed plan, but if you go and you look at that, there is a limited disturbance line, LOD, it's designated. So any tree that falls within that LOD is proposed to be removed.
Awesome, thank you. I presume you're familiar with the bulk regulations applicable in the R2 zoning district, is that right?
I would have to look at them to know specifically numbers.
I'll remind you, let me know if you think differently. In the R2 zone, I believe the minimum front yard setback for a detached single-family home is 25 feet, correct?
Mm-hmm.
And as planned, the dwelling proposed for the subject property is set back 28.5 feet, is that right?
That is correct.
So in other words, this house could only be located about 3.5 feet closer to the front of the property than it's currently proposed, is that right?
Without a zoning variance, that's correct.
Correct, okay. Now in the R2 zone, the minimum rear yard setback for a detached single-family home is 30 feet, is that right?
Correct.
However, the applicant here has proposed that the dwelling proposed for 1009A Moss Haven Court be set back 58.4 feet from the property's rear lot line, is that right?
That's correct.
Okay, so as proposed, there's a 28.4 feet between the back of the proposed house and the 30-foot rear yard setback, correct?
That's correct.
Okay, and is it your testimony this evening that the proposed dwelling must be placed over top of the existing large tree? And I'm just going to call it the large tree.
Sure.
I think we all know what we're talking about. Because no matter where on the dwelling, no matter where the dwelling is located, the tree's roots will be compromised?
Yes, it's my opinion that the house, in relationship with the other management practices that we have to provide for stormwater, as well as the necessary grading that needs to be taking place for the house, and it's not just simply placing the house. It's the other items that come along with us placing the house and going through the permitting process. So it is my opinion that it needs to be up where the large tree is in order to accommodate, again, the grading and stormwater that I spoke about earlier.
But to interrupt, isn't much of the remediation going to be fee in lieu?
Well, so under the grading and sediment control plan, I'd have to look at that to tell you the specific number, but we have numerous trees that are going to be planted. I mean, we are planning to the maximum extent that we can. So we will address as much mitigation as possible on site, and then any additional will have to be addressed fee in lieu.
Sorry.
Is it true then that the proposed home couldn't be located 5 feet, 15 feet, or even the full 28.4 available feet behind this large tree?
I'm sorry, behind the tree?
Behind the tree.
In my opinion, no. Could we shift it back? Behind the tree, we could, but from everything that I looked at, I don't think then we can start to meet the requirements of stormwater management. And then we are still then digging so much of that critical root zone that I don't believe the health of the tree in the condition that it is, and now, would it even be saved?
And that testimony holds up even if this dwelling were pushed back the full 28.4 feet?
In my opinion, yes.
I'm going to direct your attention now to the existing and proposed condition sheet.
Sure.
Accompanying your site plan and application materials. Now, in the application, you've proposed to construct a dwelling 6.46 feet from the subject property's western lot line, which is the lot line shared by my client's property, Ms. Webster Giddings. Is that correct?
That is correct.
Okay. And these drawings are to scale, right?
Well, I hate to say it, I can't speak to the drawing that you have. I don't know what size it is. So the scalable drawing, so the drawing that you have is an 11 by 17. The original drawing is a 24 by 36 inch sheet. So if you're asking me if it's a scalable drawing, the drawing that you have is not a scalable drawing. You could not lay a scale down on it. The drawing I have in front of me, a 24 by 36, yes, that would be a scalable drawing.
Do they represent accurate proportions?
Yes, it does.
Regardless of the size of the sheet?
Oh, absolutely.
Cool, thank you.
Sure.
Can you tell me whether these drawings depict any trees on Ms. Webster Giddings' property that are parallel to the proposed dwelling and near the shared lot line?
Yep, absolutely. So if you go to it's easier to see it on the existing condition sheet. If you see, there are 3 trees that run parallel to their home. I guess about 5 foot off the property line, about that, 5 foot. I mean, give or take, they're running similar, you know, and pretty much parallel to that property line.
Just for clarity here, are you referencing the 28.7 inch diameter tree as well as the 21 inch diameter tree towards the front of Ms. Webster Giddings' property?
Yes, I am.
And it's your testimony that approximately they're about 5 feet off that shared lot line?
As I'm scaling them on my, yes.
So,
and those trees were surveyed likewise to our property as well.
So it's your testimony then that these trees are roughly 11.5 feet from the proposed dwelling?
Correct.
Do you have any testimony as to whether or not the proposed dwelling would affect the critical roots of these trees?
Well, I can say they will impact them. It is up to the developer, and we have that noted on our development plan for the grading and sediment control plan, that it's their responsibility to do the required root pruning and protective measures to save any trees within that LOD or even adjacent to the LOD.
Just to be completely clear here, is it your testimony that setting the proposed dwelling back 28 feet from the large tree will nonetheless compromise it? However, setting the proposed dwelling just 12 feet from mature trees on Ms. Webster Giddings' property may not compromise those same trees, depending on the development techniques?
Well, I'm not an arborist.
Okay.
But what I would say is that the 27 and 21 inch tree, critical root zone, substantially less than the large tree on our lot. Pushing the house back would get it even more into the 48 inch tree. So I would say holding it up towards the road is the best plan for the adjacent trees. Now again, I'm not an arborist, so I can't speak of the health of the tree or the viability of that tree. Like I say, we do note on our plans that it is the responsibility of the developer to take all protective measures, as well as the city will review that, that requirement also.
You jumped ahead of my next question. Just for clarity, I would like to confirm you are not, in fact, an arborist, correct?
I am not.
Do you feel comfortable opining on the survivability of the large tree despite being not being?
No, I wouldn't speak of that.
Okay. Does this dwelling have a basement proposed?
Yes, it does.
Okay. Does that basement encapsulate the entire footprint?
It does not underneath the garage.
Okay.
Which the garage is on that western side.
That's all I have, Mr. Chairman.
Thank you. Kim, any questions for Mr. Ford?
I have none.
All right.
May I
Next
redirect?
witness?
Or may I redirect briefly, Mr.
Sure.
Chairman?
Sure.
In terms of your review of the application and your interactions with the State of Maryland Critical Area Commission, are all existing vegetation on both your property and adjacent properties considered and make recommendations as a mitigation?
We're required to mitigate for any trees being cleared.
Correct. And whenever you build a structure, whether it be on an adjacent property or whether it be on your property, that has to be accounted for pursuant to the State of Maryland Critical Area Commission, correct?
That's
And
correct.
that's something that is accounted for within your plans.
Correct.
And so all trees, whether it be on your property that we're working on here, Lot 6, or any adjoining properties, also account for their vegetation and their overgrowth as well.
That's correct.
Okay. I have nothing further, Mr. Chairman.
You have another witness, I assume?
I would ask the owner of the property to testify very briefly, Your Honor.
All right.
Good evening. My name is Patrick Mona. I reside here in the city at 141 West Street.
Mr. Mona, do you affirm, subject to the penalties for perjury, that the evidence you give tonight will be true to the best of your knowledge?
I do.
Go ahead.
All right. Mr. Mona, you're the owner of the property that we're talking about here, which is Lot 6 along Moss Haven Court within Eastport, Maryland, correct?
That's correct.
And you've heard the testimony of MAF and Associates, that's the development plan, correct?
I have.
And you hired MAF and Associates LLC to assist you with this development plan, correct?
That's correct.
And is it your testimony that you intend to respect all the recommendations of your development team?
Yes,
And is it your intention that you respect all the recommendations of the State of Maryland Critical Area Commission as well?
we do.
Is the application as submitted any different than any of the other homes contained within Moss Haven Court to the best of your knowledge, understanding, and belief?
That's correct.
And what's your basis for that belief?
We have developed a house that meets the city requirements as well as the critical area requirements. We are consistent with the footprint coverage of the adjacent houses, 1011, 1013, 1015, and 1017 Moss Haven. So we feel confident that we are, developing in line with those requirements.
Now, have you had the opportunity to examine other structures, and by structures I mean single-family homes along Moss Haven Corridor within the community to where you intend to build this structure?
I have.
And is your proposed structure that we have identified within the previously filed application, is it in consistency with other structures within the neighborhood?
Yes, it is.
All right, now I'm going to show you what's been probably not admitted as an exhibit, but I can give to Kim to give to the board. But if you can identify the photographs that have been submitted here.
Yeah, I think we got those. Yeah. But it wouldn't hurt to distribute them.
If you have them, I'll just ask the board to take notice of them.
Yeah, we have them, but it's nice to have a copy in front of us.
Thank you, Mr. Chairman. So, Mr. Mona, if you can tell me, what was the purpose of these photographs that you took?
I wanted to provide this information to show that we are consistent with the frontage and lot coverage with our footprint of the adjacent houses. Now, there are a couple in this picture that are on larger lots, which would be those first two. But then as you go to pages 3 and 4, those houses are on similar size lots as what we are building on. They're 6,500 square feet.
Mr. Mon, are you requesting any variance to the lot coverage restrictions upon this particular piece of property?
No, we're not.
And so would it be fair to say that you're attempting to build consistent with what already exists within the neighborhood?
That's correct.
And have you asked for any side or rear or front yard setbacks in order to construct your single-family home?
No, we haven't.
And would it be possible to build a larger single-family home if you requested those setbacks? So would it be fair to say you could build bigger if you wanted to and ask for those variances, but you're choosing not to?
We could, yes.
Okay. And in terms of the lot that you sit on, is your lot any bigger or smaller than any of the adjacent lots that we've previously identified as 4, 5, 6, 7, 8, or 9, or 10, or 11?
They are the same size, 6,500 square feet.
All right, and then to the best of your knowledge, belief, and understanding, they've been that size since they were originally subdivided in, I believe, 1929?
Yes.
All right. And in terms of the vegetation that is currently existing on that lot, did you have any expert come out or any individual come out to give you an assessment of the large tree that we're currently discussing?
I did.
And what, if anything, did you learn as a result of that investigation?
I hired Chesapeake Arborist, and after reading the comment letter from Mrs. May, who is the adjacent owner that I purchased this particular lot from, she stated in her comments that that the tree, for years she worked with Bartlett's Tree Service trying to keep the tree healthy, but this tree is near the end of its lifespan. So when I read that, I wanted to hire an independent arborist to come out and review it as well. And his comments were the same, that this tree shows signs of decline due to dieback in the canopy of the tree. Also shows browning and curling leaves, which indicate of disease. While inspecting the tree, he noticed 2 wounds that have been covered with metal. And I believe you should have pictures of that, which I forwarded to Ms. Burke. One of the large trunk wound was one was a large trunk wound and the other was a smaller branch wound. In such cases, water works its way into these areas, causing unseen rot to occur, which in due time can cause a tree to become a safety hazard to a structure or pedestrian. With the high signs of stress growth that were noted on site, this tree is in its last stages of life.
So is it your understanding and belief based on the arborist you hired that this tree will need to be removed in the very near future?
That's correct.
And is this the largest tree upon your property that you need to remove to comply with this particular variance request?
That's correct.
And you've had an opportunity to review the other homes in the neighborhood?
Yes, I have.
And is it your belief that at any point, any of the homes in your neighborhood could have been constructed, if not for this type of variance at some point in time?
That's correct.
All right. Is this the least restrictive request that you can put forward to the board in order to build your single-family residence?
Correct.
All right. And
No, I have not.
okay. I'm just going to show it to you. We'll publish the board one last exhibit that has not been previously submitted. 5 copies. Clerk. All right, the document that is tendered forward is a photograph of the home that you intend to prepare and build upon the lot.
That's correct.
Is that a true and accurate depiction of the home that you intend to build upon the lot?
Very similar, with the exception of exterior finishes, colors may be different.
Okay. But otherwise, keeping within the footprint that has already been tendered as part of the proposed plan submitted by MAF in response to this variance request.
That's
So
correct.
it's consistent with the floor plans and everything else that's been submitted.
Yes, and that was not prepared by MAF.
Oh, I apologize, excuse me, proposed by a 1-12, proposed in conjunction with your plans to develop the Moss Haven residence.
That's correct.
Okay. I have nothing further of my particular witness subject to cross-examination or redirect, excuse me.
The report of the arborist, has that been made an exhibit?
We can make it an exhibit. Mr. Chairman, I believe I have How many copies?
I have 2.
Okay, we have only enough copies for the board to have one publication. I apologize, I just got it because we just received it this afternoon. So I can publish to Madam Clerk and give a copy to Ole. A copy of the photos I have an extra pen. This one, you copy can scan and get a copy. Or publish to the board individually and publish to opposing counsel. So we did just receive it only about 2 or 3 hours ago, and I apologize for not having that to the board sooner.
Yeah, that's fine. Mr. Fulton?
Briefly, Mr. Chairman. Mr. Mona, is your contracted arborist here this evening?
No, he's not.
Okay. And this document right here represents the report that he prepared?
That's correct.
That's all I have. Thank you.
Ms. Burke, you have any questions?
I don't have a question, but I just wanted to make a statement. I guess in my original staff report, since we're talking about critical root zones, I did potentially suggest shifting the stormwater management that's in the rear of the property over to potentially reduce the amount of trees being removed, but in hindsight, then that will shift the stormwater management, which is something in the ground, into the critical root zone of the neighboring tree. So I think it's best to leave that where it is. I'm not the city arborist, but I know they look at that if the tree, as far as the drip line or the critical root zone, it's best when 30% or more of that critical root zone starts to be disturbed is when they start to worry about that tree and its survivability. So keeping the stormwater management on the other side of the property, it visually looks like less than 30% of the critical root zone of both the trees on the neighboring property.
Either of you have questions for Ms. Burke based on her?
I do not, Mr. Chairman.
Yep, redirect?
No redirect.
All right, do you have another witness?
I do not. That concludes the application of the petitioner.
Great, thank you. All right, Mr. Fulton?
Mr. Chairman, my client has no witnesses, no expert witnesses at the very least, and she's actually not here this evening. I'm not sure how you want to proceed. I know we've got a handful of folks here who are willing to testify in person. If you'd like to lump my client's argument or thoughts in with them, I'd be more than happy to, but I'd request that I go last in light of all the testimony.
We have your written statement of opposition.
Thank you.
All right, let's hear from those folks who have signed up on the website to give us their comments tonight. We have, I think, Mr. Urbancic. Mr. Fulton will lend you his microphone. You can come to the podium if you like.
Good evening, Mr. Chairman. My wife Judy and I live in the house directly behind the subject property.
You want to give us your address, your name and your address?
My name is Stephen Urbancic. My wife is Judy. We live at 203 President Street, which is at the end of a long driveway which runs parallel to Moss Haven. And our property is directly behind the subject property. Our principal concern is the survivability of 3 lovely, large, healthy American holly trees, native holly trees. It looks as if all 3 of them are within the setback area and therefore do not need to be removed for the house itself. But it appears that the stormwater management plans that are being proposed calls for the removal of at least 2 or 3 of those 3 trees. Those are important to our property for shade and screening. We would suggest that the stormwater management is important to us because we're a little bit downhill from there. but we would like to see if the stormwater management can be put into place without destroying those two or three of those trees. They're tall, they're healthy, they've got a long life, and they're important to our property, and I would think they'd be important to Moss Haven and to the general community.
Would one of you like to tell us what you know about those trees and what's going to happen to them?
So those trees, we do have holly trees in the rear that are being proposed to be removed for the stormwater. Again, stormwater must be downslope from the proposed development. What I can offer, and it's not on the variance application, but on our grading and sediment control plan that we have filed with the city, we have planning requirements. Bear with me, I'm getting to my planning plan for that grading permit. But we have a substantial portion of that rear yard after development occurs that will be planted. Just behind the house, along the property line, we have 5 trees from the stormwater that's being proposed that will be planted also. It's part of the stormwater requirement for microbial-retention, and that's what we're proposing. But just from that stormwater device to the rear property line, we have 5 trees that are being proposed in that back area. So
now, looking at your proposed drawing, is that a patio or something for reference toward the back of the lot? Looks like bricks. What is that?
I'm sorry, that is the microbial retention area. That's the stormwater that we're proposing for the site.
And where are the holly trees in relation to that?
Well, they're kind of in that area. That's why it's a little bit difficult to see, because I have requirements for so many lines on these plans, and we try to make them very clear. But if you kind of go from the existing conditions where you can see the scalloped line type representing the trees, they're where the stormwater is going.
They're the 15.3 inch trees or the hollies?
Yes.
Correct.
There's 3 of them.
Yeah, so they're being proposed to be removed, but we also have mitigation requirements that we spoke of earlier. So, not to make light of the trees being removed, but those trees are being removed, and we're actually planning multiple times of what is being removed. So ultimately, that rear yard, it will be fully established with woods, again, based on our proposed plannings.
Mr. Chairman, could I interject that if they remove those trees, as well as the entirety of the 7 trees they've talked about removing, they're removing far more than 42% of the forested area of that property. I understood that the removal of the large tree in front was required, and that required the variance that you're seeking here now. The proposed removal of the other trees is going to far exceed that. And I think it would be in the best interest of the community, my wife's property and my property, that everything be done to save at least those 3 Native American holly trees.
Thank you, Mr. Urbanchuk. Mr. or Mrs. Smith?
We don't go together. Susie Smith, 1012 Moss Haven Court. Is that it?
That's that. Tell us what you have to say.
I have actually filed comments in addition to wanting to say in person that I am opposed to this variance request. I certainly concur with the Urbancic's comments before me, and probably all of the 15 or so residents of our street that are going to be, who are either here and going to be talking, because this is so impactful of our community. It's not a good day if you're a tree, clearly, in the conversation today. The property owner bought this piece of property. They decided on planning of a house, and they believe they are entitled to that house without the consideration of the code, with references for critical areas, without consideration of the trees of the neighbors, and kind of without consideration of anything else that is part of the code and priorities of the city of Annapolis. The team has the responsibility of both transparency and facts. And I think that's the problem here. They've got a house, it could go here or it could go there, but they feel entitled to that house. And the codes that we are discussing may or may not fit that house there. This neighborhood, contrary to Ms. Burke's representation, is not, there's a few houses that are similar to the one being proposed, but most are not. The house on the other side of this property is not anything like. So the fact that the city is supporting this is a little misleading, to be perfectly honest. The board should value the trees, and the neighborhood certainly values those trees. It's important to us. Why does why, even if you took this down, why do they need 42% coverage? I mean, it's sort of, which way is it? Are we looking at what's being taken down, or are we looking at what kind of house they want to build? What is proposed? So again, I'm opposed to this variance, and I'm supportive of what our neighborhood is about to talk to you all about. Thank you very much.
Thank you. Mr. Smith?
Good evening, everybody. I will be mercifully brief. My wife and I chose to buy the house we are in at 1012 Moss Haven Court, in significant part because of the verdant greenery and build-out settled nature of the street. And that's why I object to any developer stripping 42% of the mature trees and vegetation on the currently vacant lot at 1009A Moss Haven Court. The mature trees, including the large oak front and center on the property that's been discussed at great length here, give Moss Haven Court the distinctive appeal and contribute, in my opinion, to the inherent value of every property on the street. Removing 42.25% from that lot will materially diminish the value of our homes on the street. The variance should be denied.
Are you suggesting you had an expectation that that lot would never be developed?
I did not have an expectation one way or the other.
Or that it would be developed without taking down a substantial number of trees?
My objection is to the 42% versus the allowed 30%.
Okay.
So it's here, you know, that is my objection.
All right. Thank you.
Thank you.
Mr. Elbert?
Thank you, everybody. I'm Michael Albert, 1006 Moss Haven Court. My wife Donna's here as well. So I object to the design and the build of this house, this size of house. So to take emotion out of it, I did some math, right? Because trees are always emotional, right? The environment of that. So we'll do some math. And in my response, I must have been mistaken that I thought the minimum side variance was 7 feet, right? But I guess I was incorrect on that. The county has 7 feet. I guess I'm below that. The city's less. So that, I like to, I apologize for that. But then I started doing the math in the other way. There's 6 lots. There was a reference earlier that the house across, which is 1004, is significantly larger than anything else. In comparison, that size of lot is 14,000 square feet. So of course, it's going to be larger. It's relative. So proportionality matters. We talk development. On the 6,500 square foot properties, there's 6 developed. 1 is not. Of those 6, the average square foot for a foundation is 1,100 square feet. This property is 1,500 square feet.
Would you repeat that, please?
The average foundational square footage of the 6 lots that are developed, so the base foundation, not talking square foot of the whole house.
The footprint.
The footprint is 1,100 square feet, plus or minus.
And how did you get that?
Because I did the math and went by the houses and measured them. It's pretty simple. So it's not that hard to figure out. This one's 1,549. That's 400 square feet larger, 40% increase, give or take. So that's a significant change. That is not a insignificant comparable number. In the math world, you say that is completely skewed. It's not even the ballpark. And that's my background. So the other one is, if you look at this overall total square footage, they're asking to develop, I think 4,027 square feet was total square footage. The only house that comes close to that in comparison is the one with 20,000 square feet, and that's Terry and Susie's, and their lot size. So when you look and compare that to the other houses, which an average square foot home is 2,300 square feet, of the 6,500 lots, this is 4,000. You double it. That's pretty odd. You look at the lot proportionality for square foot of house to lot size. 6,500, for the 6,500 square foot lots, it's a 3-to-1. The whole total size of the house is 3 square feet of lot to 1 square foot of the house. The house is being proposed 1.16 square feet of lot per square foot of house. So you can see that the size and the footprint is significantly smaller. The request to take down above 30% really isn't viable. It has no basis here. The only basis it has is in a potential increase in sale. I mean, can't be discarded here. It's either in tax collection or it's in the overall sale and profit. So, it's the statement that was answered in it doesn't really answer the question or the comment about is it just for fee only or what was this for investment purposes?
Financial gain.
Financial gain. Thank you very much. But it doesn't really answer. They talk about we're requesting this variance to move trees. They didn't really answer it, so I can't really comment too much on that. Stormwater management, I think, is a good point, but I think that's also, as the engineer stated, is in the grading and elevation. Really, if you want to see that, it's where that is in there, and that wasn't part of this announcement. So I guess we'll look at that when we get to the grading and elevation, which I think is still in for comment and under review. So to say that the stormwater management plan is good to go, it's only just starting the process. So kind of misleading, I think, in that aspect. That's all I've got to say.
Thank you, Mr. Albert. As far as I know, we don't have any other people who have signed up tonight. Am I missing someone? Has someone signed up that I haven't called on? All right. All yours, Mr. Fulton.
Thank you, Mr. Chairman, and I will keep it brief and do my best not to waste time repeating anything that any of the community has already represented to the board. Yesterday morning, I did submit a statement in opposition to the variance. It wasn't necessarily intended to be a public comment, but I would just take this time to request that it is included with the record.
You're a party, and that's equivalent of a pleading. It's in the record.
Understood. Thank you, Mr. Chairman. That said, I will repeat one standard which I think is pertinent here. It's a standard under Maryland law and our city's code, and it provides that the board shall presume that a critical area variance does not conform with the general purpose and intent of the critical area program. It's for this reason that an applicant must meet each and every variance criteria in order to have their variance approved. The inability or the failure to establish or satisfy just one criteria is fatal to an application, and if that's the case, the application must be denied. From the outset, and I think this is pretty representative of the folks that did come testify this evening, I take Mr. Forgan's word for, in terms of the trees which are slated for being removed are somewhere depicted in these plans, but the truth of it is that it is not clear. And it wasn't clear to me when I saw the plans, and I doubt it's clear to the folks along Moss Haven Court who have also reviewed the plans. While it's clear they're seeking a variance in the amount of 12.25% from a 30% clearing limit under 215490C, the trees, which they are specifically proposing for removal, are difficult to ascertain. I'm not sure I've actually understood what proportion of this 42.25% they are seeking is actually represented by the large tree, and whatever balance is represented by the various other trees which they're slating for removal in the rear of the property. Without this information, it's difficult for the public, specifically neighboring and adjacent properties, to fully understand the effects this variance will have on them, specifically my client's property, which is adjacent to the west, and the property adjacent to the south along that southern lot line, Mr. Urbansk's property. It's also conveniently difficult to understand whether this 42.25% clearing actually is the minimum necessary to afford variance relief here. I understand that the city has, to a degree, walked back its comment that it included in its staff report, but originally, the city's comment number 1 in its staff report stated that or suggested rather, that trees toward the rear of this property could be saved if the stormwater management facility is shifted to the west. Now, that very idea would suggest that there is room to minimize the variance that's sought in this application. If it only takes one tree to reduce that 42% to 40%, then this is not the minimum variance that's actually required for the project that's proposed in this application. What is clear, however, is that this variance would injure my client, Ms. Allison Webster Giddings' property, and that the criteria under 212850E, one of the general variance criteria, simply cannot be met. There are 2 mature trees on adjacent property that are approximately 10 to 12 feet on the proposed from the proposed dwelling. I'll take a second to note at this point that we have not heard any testimony from an arborist. So while Mr. Forgan may own an engineering company, it's difficult to understand how positioning a dwelling 28 feet from a tree will compromise its roots, while positioning that same dwelling from just 12 feet from neighboring properties' trees won't compromise those roots. And by virtue of that very idea, I simply fail to see how that criterion can possibly be met. With that, I'll add in brief conclusion here that, the specific evidence submitted in the presentation this evening and conjoined with the relatively brief statement in support that was filed on behalf of the applicant in various instances is short, in my opinion, of constituting substantial evidence, which is the threshold required for one of these decisions to be upheld. And with that, I would ask that the board take to heart the comments submitted in paper and in person this evening and deny the variance requested by the applicant.
Thank you, Mr. Fulton. I don't think we heard any evidentiary testimony, but Mr. Scruggs, is there anything you need to clarify?
Yeah, I'll be brief. Terrence and Suzanne, or Smith, apologize if I mispronounce your name, Mrs. Smith, have a 4,000 square foot home. The house was built in 1950. They've lived there since 2020. You've got Stephen and Judith Urbanski. Their house is 3,900 square feet. They lived there. The house was built in 1993, and they lived there since 2022. Michael Elbert and Donna Elbert, 1,846 square feet. House was built in 1973. They lived there since 2016. When you look at the other homes in the neighborhood, whether it be Ben Sutherland's home with his wife Bonna, 7,000 square foot lot on unimproved at this particular point in time, they'd have the right to build. If you look at Walter Engelhart, his home is 2,768 square feet on a 6,500 acre lot, 1019 Moss Haven. It was built in the 1980s. If you look at Patrick Jane Bannon, 2,280 square feet on 6,500 acre lot, 1994. August Steitzel, 1015 Moss Haven, 2,512 square feet on a 6,500 acre lot built in 1983. When you look throughout
Mr.
this.
Bannon raised cattle on those 6,500 acres?
I'm sorry, 1,600 square feet. You know, it's been a long day, Mr. Chairman. I was in court all day and then I get to come here, lucky me. So one of those days when numbers tend to run together in my head, but I can see it even if I'm not speaking the way that I should be. But at the end of the day, my larger point is that all of the lots contained within this community are roughly the same size. And if they're not the same size, they were combined lots at some point between when this community was subdivided in the 1920s, which is a long, very long-winded way of me saying that my client is asking for the minimum relief possible. And so all he's asking for this particular board to do is say that there's a large tree in the center of a lot that is buildable and has been buildable since Christ was a carpenter, long before any of us in this room were born. And that tree is dying pursuant to the arborist report that he read into the record and submitted to this board, that all we're asking is that he be permitted to do what every single other person in this room in opposition to this request has been permitted to do, which is build a single-family home. There is no one in this room, not a single person, who has objected to this request that would have been able or permitted to build their home if we take the time they built it and apply it to 2024 standards within Anne Arundel County. That's why we have the variance requests. It's why we have the ability for this board to afford relief from the city code when it doesn't apply or when it amounts to an undue burden or an undue hardship. And when you look at the letter that was submitted, the explanation letter by MAF and Associates LLC by Mr. Forgan, which I think was incredibly well written despite counsel's assertion of the otherwise, and I do respect Mr. Fulton to the highest degree and the work of his firm, it's to say that all the categories required to be met by the county code A through G have been met by this request. Mr. Fulton and I do a lot of the similar work, which is zoning and building and variances within the county, within the city, throughout the state of Maryland. And he and I both have a sentiment that people tend to get sentimental about the neighborhoods to which they are buying into.
Is that evidence?
And when I say that Mr. Gallagher hit the right point, which is to say that no one should expect that an undeveloped lot will always be undeveloped, that is the key to this entire argument, which is there's no reasonable expectation that a person isn't going to come and want to do the exact same thing that they did, which is have a single-family home of their own. And that's all we're asking for is the minimum requirements necessary. It's the minimum request to build what already exists within the home. And as you heard the testimony, a home that is of a similar nature and character that already exists within the community. So when you look at the requirements necessary for a variance, and when you look at the application as it outlines the request for variance, A through G, I find that this application should be approved, and the evidence supports that, and the testimony supports that. And not to put too fine a point on it, the only person to bring an expert to this hearing was the applicant, to talk about stormwater management, to talk about the appropriate placement of the home and the rationale for doing so. And I think that should be given the weight and due consideration by the board, and I do respectfully request that the application be approved as submitted.
All right, those were nice closing arguments, but we're not quite there yet. Let's give the board a chance to ask questions. Is there something you need to inject, Kim? No? Okay. All right. Questions from the board, Mr. Zazali?
I would just like to clarify, I've reviewed the existing condition report, but there was some testimony and questions about trees that are parallel to the property line and the 3 American hollies. Yeah, sorry. Those trees are wholly on the subject property, right? We're not talking about trees that are physically located on somebody else's property.
The trees that are being removed are on their property.
Well, there was some talk about the viability of the trip was referencing some trees that were parallel to the property line,
right,
that were smaller, but would end up being closer to the foundation than the other tree house would. Those are all, but every tree that we've talked about today, regardless of the context that was talked about, is on the subject property, right?
No.
That's what perhaps you could show me the trees, because I'm looking at the property line, and when you were reading out the dimensions of those trees, they look like they're on the property.
Would you mind if, Mr. Zazali, would you mind if I came up to your?
No, please.
Mr. Chairman, along with Christian's comments, I am very confused about which trees are being removed and not removed.
Yeah, I was.
And their location. I don't feel like we've received a clear diagram.
I'm referencing these two.
We'll deal with
Testimony
I just
from the public
wanted
was
to-
referring to some trees down here. Holly is down here. I was referencing.
This is the limit of disturbance. That is not the property line. This is the property line. Those trees are on which property?
That is not the property line, that's a sewer line.
Okay, so the limit of disturbance is a 0 lot line limit of disturbance?
Limit of disturbance is consistent with, there, see that little margin right there? That's the limit and the proposed setback. That's like
So
half
these trees
are on this property.
Okay, so this is that 4 or 5 feet that you were guys referring to. Okay, I got it. So whoever made the comment that there's an awful lot packed on this postage size. I mean, the limit of disturbance, the property line, the silt fence, the existing subdivision, it's all sharing a line in this 8.5 by 11 area. Okay, I got it.
So, Mr. Zazali, I think it's confusing also because there's a sewer easement or a storm drain easement on the neighboring property. So that's adding to the additional lines over there. And those neighboring trees are actually on top of the sewer line.
Okay. More questions, Mr. Zell?
I had another one, but it's evaporated for the moment.
We can come back. Michael?
Mr. Moto, just clarify for me, you purchased this property, I believe this property was for sale, along with, it was a part of another, Miss May, I believe, was the adjoining property, she owned both those?
That's correct.
properties you
Miss
purchased
May
those?
owned both, yes.
And she still lives in that house?
Yes, she decided to keep her existing house, which is now being rented out. I believe she moved to Georgia, and she decided to sell the vacant lot, which that's what I purchased in 12 of 23.
And just for my clarification, and council provided these just to clarify for me, this is, and I've looked at your design, this is substantially what it will look like?
Very similar, yes, sir. Yes.
Very similar, yeah,
Yes.
including the garage being a 2 versus a 3 that you showed in your design?
That's correct. It's a 2-car front-load garage.
And setback from the road, how far?
28 feet.
If you could explain to me again, why, playing devil's advocate for Mr. Fulton, well, first of all, I know we're supposed to look at the 7 criteria that we have under our jurisdiction, and also in the critical area requirements. There's also, I mean, there is, because you're talking about light to adjoining properties and the effect on neighbors, there is a question Mr. Fulton raised about bulk. It's necessary to have a home this size on this admittedly small lot as it's been described?
Is it necessary?
Yeah.
Is that the question?
Yeah.
As Mr. Walsh, I think as Mr. Mona is the owner of the property, the question may be more appropriately directed to Mr. Fulton as the individual who roughed out the sketch of how this is going to be laid out, or at least as the organization responsible for how it's laid out.
That's fine. Thank you for directing me accordingly.
Thank you, Mr. Walsh.
I'm sorry, your question?
Sure. In terms of a bulk and size, you're proposing this on this lot. It's I guess, to put in layman's term, does it have to be this big?
Let me answer.
Given the size of the lot,
Let me answer
kind of as you described, the unique characteristics.
Sir, there may be some confusion. one of the commenters kept mentioning something about 4,000 square feet. Is that what you're referring to? Because the size of the house above grade is 2,534 square feet above grade, which is consistent with the houses along Moss Haven that are built on the 6,500 square foot lots. If you pull the information off of the county sites, it shows that, and you guys have that document in hand. So I feel that I'm building a size home that's consistent. And in terms of the height, we're actually lower than 2 or 3 of the other houses that I refer to as well. I'm sorry.
Let's make sure everybody understands that. So the footprint of the house itself, I can see on here it's 37 feet wide, right?
That's correct.
And what's the depth of it?
The depth is 43.
And what's the math? 37 times 43.
That's 15. With the garage, that's 1,500.
So that's 15, and so double that is the square footage of the house.
Well, no. We're talking about finished square foot. So you would not include the garage space as a finished square foot. Now, if we're talking about lot coverage for the first floor footprint, we're at 1,500 square feet, thereabouts, plus minus. The total square foot for the house is 2,500 square feet. So you have to deduct the garage space out of that first floor for finished square footage. So we're talking about 2 different finishes.
Sorry, Mike.
No, go ahead.
No,
that's fine. Just if you could give me a little more depiction, maybe you, sir, you referred to if, as Mr. Fulton suggested, that the house were to be moved back, it might affect how it would impact erosion, some of the water runoff containment and all those things. If you could, because I don't see this, and I didn't really see this in the testimony that was submitted to us prior to tonight's meeting as to what exactly you're proposing. I heard you refer to that when Mr. Gallagher asked you about what that particular area was, the retainment area. But if you could give me some idea of how what you're proposing would be superior to what having the house moved back, or I should say how having the house moved back would be more harmful to runoff.
Sure. Moving the house back complicates things on multiple levels. To talk specifically about stormwater management, if we shifted the house back to our 30-foot setback, all the way back to the rear of the site, we still have to provide stormwater management below the house, within that 30 feet. Right. Well, within that 30 feet, we also have setbacks for our stormwater. We have a setback to the structure, as we have a setback to the property line itself. Those are 10 feet setbacks. So now we're starting to eliminate the area that we have to implement stormwater management, right? So it decreases that area, and we can't get out of that requirement. We don't want to, because we want to treat the water that we're required to treat before it leaves the site.
The stormwater from the roof can't be treated in the front of the house?
No, because then everything's flowing downhill. We have to provide a certain amount of management for our ESD volume. The city code has a requirement to expand that ESD volume. And then we also have another volume that we have to address, and that's 10-year management. Because of the nature of the site and the manner it discharges onto a neighboring property, what we do during this design stage is we look at it and we say, okay, in an existing condition, a certain amount of runoff from a rain event leaves that site today. When we do our design, we mimic that same runoff condition in a post-developed condition. So we're figuring volumes based on certain calculations that dictate how much volume we have to store on site and manage before the runoff is just let go. And that's how we determine the size of our stormwater management devices that we implement on these sites. Obviously, if we have a house that's pushed back and we start to increase the lot coverage that we need to get back to that house in the driveway, well, anytime we start to increase our numbers for lot coverage, we start to increase the number that we're required to manage on site. So now we're going to get into another issue where, we have a lot coverage limitation as well. Now, we're not seeking a variance for that, but if we start to manipulate the placement of the house and we start to shift it, even if the house were to go smaller, we're going to start to quickly get to that number because the more we stretch that house back, the more driveway we need. So I believe even that. But let's talk about the trees. There are 3 trees that I know it was difficult to see on the plan that you have because you have a 11 by 17, and the plan is really drawing the scale on a 24 by 36. If we were to shift the house back, well, let's talk about the placement of the house as it sits today, or on the plan. So we have a garage. Obviously, the foundation that's cut in the ground is much less for the foundation for a garage than it is for the basement of the house. So right now, we have the house shifted up. It does sit closer to smaller trees on the neighboring site, which we talked about, root pruning, protective measures to save those trees. But if we shifted that house back, now we're starting to get into a tree that we're limiting our impact to with this design. If we shifted the house back, more of the impact of that foundation gets closer to that 48.2-inch tree that's on the neighboring property than what we're proposing right now. So let's put aside stormwater requirements. Let's talk about just shifting that house back, trying to save the tree that's on our site, which we can't do. We start to impact the critical root zone more with the foundation of the house than we are right now in its current location, because now we're talking about more impact to that overall critical root zone than what we're showing now. And then then the problem compounds with what we discussed about stormwater. And we have to address stormwater with our grading application.
Michael,
I've taken a bit of time. Thank you, Mr.
Dr. Chen?
I have several questions. First of all, I'd like to express that I'm very frustrated because from the beginning, I can't tell what trees are being removed and which ones aren't. So I would respectfully request that one of the parties, if not all, provide the board with a very clear drawing. I mean, I get the scallops. I don't have red on what was provided to me, so I have no clue what trees are coming and going. I understand there is the one tree in the front, there are the hollies in the back, but I would very much like from the city a drawing that shows your understanding of what trees are going to go. Okay, then Ms. Burke, I know that Brian Adams went out and he provided his opinion of the critical root zone. Did he comment at all or look at the neighboring trees that are presumably part of this continuous canopy that involves the lot in question?
What he said to me is that if he felt that any measures that would need to be taken with the development, to like the root pruning or anything, whatever the arborist terms are, that he would make those comments at the time of permitting.
Did he comment to you that he felt like that there were steps that could be taken?
Yes, he didn't come back and say, well, there's no way these trees are gonna,
Okay.
He said those trees were in good condition on the neighboring properties. The one that he looked, the ones that are on the property line, he didn't look at all of the trees.
Mm-hmm.
And he did, as he said in his memo, look at the main tree on this lot also, which he said which he felt was in fair condition.
Okay. And then the 42% versus the 30%, is that 12%, in your mind, that includes all of the trees, 7 trees that are being removed?
Yes.
Okay. I'd like to ask the applicant if your arborists commented on the neighboring critical root zones, and if they commented on how you would go about preserving, making sure that the neighboring trees were kept alive.
Yes, he did look at that, and he will be providing those measures when the foundation is being excavated. He'll be there on site. Yeah, he'll be there on site providing the root pruning measures.
Then I'd like to ask Mr. Fulton, so on the subject of unwarranted hardship, this is a buildable lot. The applicant has the right to build on this lot. Why is preventing him from building a house on this lot not an unwarranted hardship?
Could you rephrase your
So is there a house that he could build that was livable with that? Can we ask the audience to please be quiet?
Ms. Chen, in response to your question, I think candidly a smaller house is still reasonable on this lot.
And so what would you estimate the size of the house would need to be in order to preserve not have this 12%?
If I had the numbers which showed the percentage of that 42.25% for each individual tree, I think I could very accurately answer your question, but I don't have that information. I know that it seems pretty well understood that this one single tree comprises a majority of that 42.25%. But if it's not all of it, I can't tell you what trees and where meet that balance, the difference, and I can't answer that question with accuracy.
Okay.
My final thought would be, there is no question that the reasonable expectation of purchasing a residentially zoned lot is to build a single-family dwelling on it. That is universally accepted. In this instance, it's our opinion that the house could be smaller and pushed behind the front tree. Simple as that. Even though it's currently within the setbacks required by the code, there's no evidence before the board that supports something to the effect that this house could not be slightly smaller and pushed back 5, 15, 20 feet behind this large tree, which would, in all likelihood, eliminate the need for the variance so long as that 30% threshold is still met.
So that's why the map of what trees are being removed is so important to me, because we have testimony that the hollies in the back are very valuable. I respect that. And then we have this tree in the front. So at what point do we say that this is an undue hardship to the applicant, that this lot is full of trees, he needs to build a house? Where do we draw the line?
I'm not going to make the applicant's argument for him, but I would say if there's the standard is what it is. If they can't develop this lot without clearing more than 30%, then they are due a variance. It's our position that they can develop this lot under that 30% threshold, largely by virtue of keeping the tree. And just not to beat a dead horse here, but I can't tell you what these numbers look like if we keep the tree and start looking at whatever smaller trees, including these holly trees toward the back. We're going to look at whether or not they're preservable, which I'm of the opinion that a few of them probably are. Then certainly this is not the minimum variance needed to afford relief here. I recognize that the large tree probably comes close to that 30%, if not crosses it. But I just can't tell you, to what degree the group of trees crosses it, and whether or not we're at 42%, we're at 38%.
Yeah, helpful, thank you. And then, Mr. Chairman, my last question to all the parties in the room. As to the requirement that it does not adversely affect wildlife or plant habitat, does anybody, the city applicant, Mr. Fulton, have any evidence to provide to this board, one way or the other, that there is or is not any impact?
I'll go first, if you don't mind, Ms. Chen. I've spoken at length with my client. It's unfortunate she can't be here. I would love to have her testify as to her thoughts to that, in response to that very question. I think her home and the home next to hers, so that would be 1013 Moss Haven, were constructed within the last 30 years. And my conversations with Ms. Webster Gidding, during those conversations, she's represented that construction really deteriorates the plantings between these homes. Now, granted, this is in light of the space between her home and the home on the other side. But as I understand it, the height of these homes, these dwellings that's allowed on these lots, really impedes and prohibits viable growth between them. It doesn't allow great natural stormwater management. The plantings don't get too high, they don't get too firm. And I can't help but imagine the same scenario would take place here if the 1009A Moss Haven became a construction site, and in all likelihood eliminated a lot of the existing plantings. No matter how viable they are currently or to what degree they're assisting with stormwater management, it would not help.
So you're relying on the opinion of your client?
Absolutely,
and
yes.
Not any expert? You can't provide us with any expert?
Not this evening.
Okay.
And Madam Chairperson Chen, I can let our expert testify to that particular comment, but the only statement that I would make in advocacy for my client is that there's a reason we have the State of Maryland Critical Area Commission, and they provide recommendations for mitigation, and the recommendations they provide satisfy the requirements that you may have, which is any disturbance to the soil, whether it be in City of Annapolis, Anne Arundel County, or anywhere in the state of Maryland, comes with regulations and recommendations of how you mitigate that disturbance. And so when you look at the recommendations of Ms. Catherine Durant, all of that will be satisfied by the plans that have been submitted by the applicant. And it's all been taken into consideration, and it's all a continuing and evolving consideration as disturbance to the soil occurs. So again, MAF can talk about how that's going to be accounted for, but when you look at the recommendations of Ms. Durant from the state of Maryland, you can see that they were very cognizant of the fact that disturbance could cause problems to vegetation or native wildlife, and that is why they require any applicant, any builder, to mitigate any such disturbance to the soil. And that's been accounted for in the plans as submitted to the board this evening. And again, I think MAF can talk about how they're cognizant of the fact and what they do to mitigate those concerns you may have. So I'll ask MAF to talk about how they account for disturbances to the soil, whether it be vegetation or wildlife or otherwise.
Yeah, so that's exactly what I was going to touch on. We are required to mitigate our disturbed area, our lot coverage, our clearing. All of those items get mitigated through the permitting process. So we are proposing to clear trees. I believe we have the right to do that. It's a legal building site. We have the variance, the variance option or application is in place for just this particular type of reason. We have a lot that was developed prior to critical area law, and critical area law restricts us at this point. So with the variance, with the state's required mitigation, we're proposing 12 new trees be planted on this site. We're also proposing 15 large shrubs that will be part of our grading permit application, which they are, that's currently under review. So the area that's being cleared, the limited disturbance that we're showing, and the area that's clear currently of trees will ultimately be planted. I mean, we have a substantial amount of plants that are going to go on this site that are being proposed with this development. So I would say that at the end of the day, when the site is developed, there will be a substantial amount of woodlands on this site.
All right, anything else, Dr. Chin?
No.
Mr. Hector? I think I can find one or two. Mr. Mona, when did you buy the property?
December of 2023.
And was your agreement of sale contingent on getting a variance?
My agreement with the purchase? No, it was not.
And you knew that the variance was within the discretion of the board. It's not something that you were entitled to.
I understood.
And so surely you, as a businessman who does this for a living, you have gone through some exercise to figure out what you would do, what you would build on this lot if you didn't get the variance. Would you like to tell us about that?
Well, excuse me, sir. I mean, at this point, I feel that with what we have designed is in compliance with the existing neighborhood. And from my discussions with Matt, is that reducing the size of the house still is not going to give us a positive effect on the canopy coverage vegetation clearing. So at this point, we have not regrouped until this hearing, or until the verdict on this hearing is given.
Well, that's your testimony. Have you looked at changing the nature of the foundation to have less impact on the trees? Building on piers or slab for a larger part of the building?
No, I have not yet.
All right. Give each of the parties one more chance. Anything you'd like to add before we close the record?
Not in testimony, no, Mr. Chairman.
Mr. Scruggs?
Not in testimony, as standing statements previously submitted.
Ms. Burke? So this is the point where we would normally close the record and begin deliberations. Personally, I'm disappointed at the I'm concerned about some information we don't have, and Dr. Chen alluded to that. More clarity on what trees are going to be removed would be helpful. I suggested pursuant to our rules, I suggested to Ms. Burke that she provide us with a comparison of the SDAT data for square footage for lots and buildings on the block, and I don't have that.
That's the one that Mr. Mona provided you with the packet.
Yes, Mr. Chairman, that information was provided to you through the applicant.
Someone pointed out to me?
We can perhaps this was addressed prior to the submitting, but it was provided to what was published to this. I
It's the one with the exhibit of the house square footage. They're attached to that is S.
Sorry if I missed that, Kim.
Info.
It's this one.
Okay, I did not see this.
Well, that's a different cover sheet, but that's the one.
This is it's a different cover sheet, but this is the document that was submitted, Mr. Chairman.
Yeah, okay. All right, and finally, I'm disappointed in the evidence that's been submitted by the expert arborists. It looks like the city's arborist report was done on Monday and circulated, and the one paragraph that Mr. Forgan has shown us doesn't carry a lot of weight with me. So my question for you, before we close the record for my colleagues, is, are we ready to deliberate with what we've got now? Or do we want to leave the record open to fill in some of these holes and come back to it? What would be your preference? I can see if you'd want to deliberate now, that's fine, or if you want to leave it open.
Mr. Chairman, the one thing I would mention in terms of your question about the arborist report and this particular tree canopy, because as you can see in the state of Maryland report, it does say 90% would due mostly to one large tree located on that lot. When you have the neighbor who owned the lot prior to my applicant purchasing it from her testifies that she had been trying to keep it alive and that she herself knew it to be dying in conjunction with the arborist report we had submitted, that would be the one thing that we would request the board to take special note of.
We understand that.
So I do have a thought. So as this hearing is principally about the request for 12.5%, right? This is the 12.5%. And I think what my colleagues on the board and the chairman are asking for is, had we been shown a list, a column of trees, the tree that's the front one, the one that's the star of the show here, was 29.7. So then virtually the very next tree, no matter where it landed, put you over 30. And then every subsequent tree cumulatively got you to the 42.5%. And then you could just move the pieces on the chessboard and see that whether it's 41 or 39 and a half or 40, it starts to become academic. And then your application stands as a finding of facts. But right now, we don't have any of the math. We don't know where this 12.5 you're asking. Where is it? Where is the 12.5? What constitutes your request for the 12.5?
Sure, and I think that was addressed by our expert, and when you look at the proposed lot coverage, which is an exhibit to the documents you just received, it clearly identifies every single tree, and if you look as he testified originally to the shaded coverage that shows where the lot coverage is of canopy, which is the variance request we're here for, it shows you where every tree is and where all the lot coverage exists, and I think that again, in conjunction with, I admit that the state of Maryland's report doesn't give you hard and fast numbers, but when the state says that the majority of the 91% wooded area is due mostly to one large tree, which is located in the center of the property that we're talking about here, I think we have to give credibility to the state of Maryland when they have done due diligence to review all of these plans and all of these applications. This isn't being done in a vacuum. We didn't come before the board.
Hold on. So the single tree constitutes 91% of the allowable?
It represents 91% of the wooded area, which the state identifies as the majority of the tree canopy, which is subject to the regulations of the state of Maryland. And I think
that's the baseline calculation from which you determine you're only allowed 30 and you're asking for 12.5.
Correct.
So that one tree is 91% of the theoretical baseline.
Correct. So put yourself in these shoes, which is if you are trying to develop a lot that's 6,500 square feet and build a home that is to the maximum allowable coverage area pursuant to the critical area definitions within the city of Annapolis and/or the state of Maryland, and you don't necessarily know at the time that you are trying to develop the lot that you need a variance, but you're told by various agencies that you do, only thing you can do is rely upon their instruction. And their instruction is you can't build on this lot because of this one large tree that by two different individuals, one of whom is an arborist through the testimony of my applicant, indicates is dying. It seems that it may be that their information has been relied upon heavily by my applicant to comply with City of Annapolis regulations in applying here. And I think that's kind of what may be lost in the communication or in the backwash of the testimony of the neighbors, which is everything that was submitted by MAF and Associates was in conjunction with the city and the state of Maryland to provide to you an application that was the minimum required variance necessary to build a structure that is compliant with code. And in order to do that, you need to remove one tree and several other trees, but replace them with additional trees, vegetation, and coverage to offset and mitigate what you are taking away. And I think that's maybe what's being lost here is we're not taking away, we're changing perhaps the nature of what looks on the property. But as MAF has stated, Mr. Fulton, we're replacing what's being removed with additional vegetation through trees, shrubs, and otherwise. And I think that may be what's clouding the issue, is that this isn't, again, being done in a vacuum. This isn't being done in conjunction with various city and state agencies to present to you an application which has been approved by the city in such a way as to be the least restrictive measure possible to allow my client to build a structure that is of a similar kind, nature, and like of everything else within the community. And I think that's what I would suggest the board key in on, as opposed to the number of trees being removed, because they will be replaced. And that's what's being missed, is we're not taking trees away with nothing. They're going to be replaced and put back in different ways, perhaps, but they will be replaced. And that's, and again, Matt can give you more information if you'd like it, but that's perhaps.
With all due respect, I understand the criteria for the basis of our determination of whether to grant the variance or not is based on some very specific language.
Correct.
One of them is minimum relief standard.
Correct.
What happens after the relief is granted, planting new trees, planting somewhere else, is largely a separate issue. It's a separate requirement. It's a condition of the variance.
Correct.
But it's not a condition to approve the variance. So I don't have the math in front of me that I could under cross-examine on some other court that I personally affirmed that the minimum relief was granted, because I don't know that. I understand that we're in very likely low single digits adjustments one way or the other, but I don't have the evidence. The lot coverage here is from what I read was speaking to impervious surface, not tree canopy.
Yeah, and it's speaking to both, and I think that may be what's.
But I didn't see that the Hornberry was 11% and the American Holly was 3% and the other American, and they say, okay, I don't see that math. I don't see the worksheet.
And I guess
and somebody did a worksheet, because you're asking for a very specific amount. So there is a worksheet that exists somewhere on planet Earth.
So I'm getting the sense that my colleagues are inclined to leave the record open for some period.
And I would also go on the record, once we get this evidence, my personal deliberation is very unlikely to be swayed one way or the other, but I don't feel that I'm empowered to enter into that deliberation without that.
Yeah, okay. And I also, with respect to the arborist information we've had so far, I'm concerned that came sort of an unfair surprise to Mr. Fulton and his client. If we leave as it appears we will, we'll leave the record open. If you and your client would like to submit some sort of expert testimony by an urban tree arborist, that would be very helpful. And I think you have a sense now of the the broader set of questions that ought to address.
I appreciate it. Thank you, Mr. Chairman.
Yeah.
Mr. Chairman, if I may, I would extend that to all the parties if you would like to submit expert testimony as to the critical root zone that includes the neighboring trees. That would be very helpful for me.
Well, it's up to you. If you want to do that, you have the opportunity to do that. So, schedule. It seems unlikely. We could, if we needed to, have a virtual meeting on July 17th, but that seems like it's a little close for what we want to accomplish. I think we are not likely to have an August meeting on August. Normally be August 6th. So it may be that we won't get back to this until September 3rd.
Mr. Chairman, I would request that if it is to be September 3rd, that it be conducted virtually due to my travel schedule. I'm happy to do it, I just won't be physically present.
We may have the capability to accommodate you, but at present we don't. I understand the city's working on that.
Okay.
That's not something that I have any control
I
over.
just won't be in the country on September the 3rd. I won't return until the 16th, and then again, not until the week of Thanksgiving.
There's a possibility we could have a virtual meeting on September 18th.
That's accommodatable. I could be here in person on the 18th.
What about virtual the third week in August, or no?
The tradition is not to have an
Nothing in August,
meeting.
okay.
And I know I'll be away. We might have other issues getting a quorum in the middle of August. That's when everybody's sort of disappeared. All right, so the board understandably likes to get this information well in advance so we have enough time to digest it. So if we're going to look at September 18th, let's try to get us whatever you're going to get us by August 30th. And there will be, if we have questions about what you submit, we can deal with that on the 18th, and then we'll go into deliberations. And you could also have a few minutes if you need it for sort of summary argument. All right, everyone on the program? Yep. Good. Okay, thank you. We try to get through these on one night. Sorry we couldn't do it. This is complicated. And we'll do our best to. So the record will remain open until the hearing resumes on September 18th. And any information you choose to submit will be submitted by August 30th. All right, thank you, gentlemen. You may be excused while we see if there's any other business we need to deal with. And thank you all for the community, for your interest and participation. That's what this is all about. So the only other thing I wanted to mention tonight is we had questions leading up to this hearing about the format of the information we were getting from Kim. And I think we've tried to, please keep it down.
Folks, we're still conducting a meeting. Folks,
please.
We're still conducting a meeting.
Take your conversation outside, please. I think we've tried to deal with getting as much as we can electronically. problems with that are obvious with the drawings. And I have trouble printing anything in PDF for some reason. I'm a Neanderthal. So I think well, what do you all think? One option is to go back. The applicants are required to submit, used to be anyway, 7 copies of everything.
They're only, so everything is now online, so nobody is supposed to be submitting any paper copies. But we can start asking for paper full-size. So I'm just printing them out on 11 by 17 in our office because it's,
I would ask
we're paperless now. So.
I would ask them for full size.
Okay.
I have a lot on my computer. Most of you guys don't even bring a computer, but it's very hard to deal with it on a computer in this format. So let's certainly do that. You can ask them to do everything in 7 copies if you want, or just the big stuff, and then you can print the other stuff. Up to you, Kim. But I think we all
do it on an as-need basis if it's something
we'd all like to
this
see
technical.
hard copies of things.
Okay.
The problem is it's an expectation of hard copy. We're getting the packet, but it's incomplete, and some stuff.
Right, right.
I'm not sure what I missed. Right? Like, I don't know what email I missed.
Yeah.
But this
So you're getting.
You would ask for, Mr. Gallagher had asked for additional information after he received the packet, so it kind of piecemeals in, and then I try to.
No.
Yeah, and I do want to say, Kim, thank you very much for getting us that information. It was super helpful.
Sorry, I overlooked the.
That's okay.
I did too.
Yeah, no, but thank you.
All right, so then, unless something comes up, it's an emergency, you'll talk to me, but in the absence of a decision to the contrary, there's no August meeting.
Okay. No, that's fine.
And there's no second meeting in July.
So I guess my question is there going to be, this will be continued to the virtual meeting in September, but is there going to be a in-person meeting?
We can have one if you've got agenda items for us.
I think I'm going to have at least one thing.
Yeah.
And the applicant may want to come back without us determining. It's up to him.
Okay, well, we'll ask him that.
He could send different counsel, he could come alone,
Well, no, he'll be here on the 18th.
but if we have a regular meeting on the 3rd.
But we're not going to deal with this on.
Okay, that's fine. Just, it's on the record, we're not. He's coming in on the 18th, and that's that.
But there will be a quorum for September 3rd.
Everybody good for September 3rd? I'm good.
Who the heck knows? I can't even.
Okay.
I can't spell my middle name.
That's 3 out of 4, so, or 4 out of 5.
Okay. So I think we're good for September.
All right. Yeah.
Well, that one was complicated.
Mr. Chairman, I move we adjourn.
Second.
All in favor?
Aye.
I would have been ready to vote if you guys wanted to vote. But I think it's better to do it this way. If a decision